Okay, I believe we had a problem. I'm starting picking up where we left off. I believe, real close to it. Let's see if we can get through this. I really hope so.
Need to amend our laws to make sure we include derivatives in our lending limits. The bill also adjusts the fees, as I discussed, with respect to just equal distribution among banks and trust companies, because I could only, at this point, as director, assess banks, not trust companies, with assessments, as opposed to fees, and it also reduces fees with respect to IT and trust because of the enactment of the assessment. It also deals with parity between state chartered banks and national banks, creating
Section 3 of the Act, occasionally we have situations where the trustee no longer exists, has gone out of business, or does not want to act. Section 3 provides a mechanism for providing notice on the record that in fact that the debt has been paid. That's basically what the bill does. Thank you.
Okay.
Mr. Chairman and council people. My name is Jonelle Wheeler and I represent the Escrow Association in Washington, and also in my real job I have a company that does reconveyance tracking for escrow customers. And this bill is long overdue in being of record, because we have lenders who go out of business, who after they get paid they're gone. I have a lender that is a big bank that I have been fighting with for 6 years now to get a reconveyance out of him on 2 different properties, and I cannot get the reconveyance. I have proof that he got paid, and they are not reconveying, and so they end up clouding these people's title, and it causes them problems down the road when they sell or they refinance again.
Senator Benton.
How in the world do you pay for somebody's property and not get a reconveyance out of it if you're using a proper escrow company? The escrow agent is supposed to be looking out for the purchaser's interest as well as the seller's interest. So how does that happen?
Well, and that's what my business does, is I am a contract person for the escrow company. So I follow that deed of trust, and I make sure that the lender gets it reconveyed.
But the escrow company, excuse me for interrupting, the escrow company should have never closed escrow without the reconveyance.
No,
Listen to
sir,
this.
they cannot. They have to close escrow.
Yep.
No bank will give a reconveyance until they've been paid off, and the transaction closes before the reconveyance gets
But
done.
isn't there a promise from the bank to deliver a reconveyance?
Yes, there is, and they don't do it.
And they don't honor that.
They don't. And a big bank doesn't honor that.
Really?
Yes.
That is amazing to me. So
It's
they
more
can
than
get their
amazing.
money and screw over the owner.
Exactly.
Even though we're relying on you, we being the owner, relying on you, the escrow company, to make darn sure that the reconveyance is handled.
The law gives us nothing to bang them over the head with. All we can do is fight
Amazing.
with them, call them, fax them, and they don't do their job.
Amazing.
Danny, they're beating up on the banks. You're supposed to, come on. You want to testify now? Oh, you do? Okay, well, that'll be round 2. All right, go ahead.
My name is Dwight Bickle. I'm here today on behalf of the Washington Land Title Association. I'm also a 30-year counsel for title insurers in the state of Washington and a real property lawyer. I want to talk a little bit about what this bill does not do. I think we've got the essence of what it's supposed to be accomplishing. The first thing it does not do, it does not interfere with the role of the person that's the borrower that has a debt with the bank. This would only come into play if a borrower agrees on who to pay and how much to pay, and the lender agrees on how much should be paid. So the prerequisites of this bill are you have an escrow with a borrower that wants to be paid, escrow has the duty of making the payment, and the lender says, here's how much to pay us. Now, for Mr. Eliason, I will say I have agreed. Almost all banks process those properly, and they usually go through fine. But when they don't go through, often it's because the lender is out of business, or the people responsible for doing it didn't get it done, and later it's just impossible. Almost every state has some provision that gives escrow the power to request the reconveyance. We need that for this state. The next thing this bill does not do, it does not interfere with the responsibility of the trustee that's supposed to file the document. So when the escrow company has the power to request the reconveyance, it's doing so in the shoes of the lender. Please, trustee, reconvey this. So the duty of the trustee is to obtain whatever is necessary to evidence that payoff and clear the title. Finally, the default provision in this bill that if the trustee does not do it, so basically the banks have had their opportunity to fix it correctly, as is their duty. If they don't do it, then the escrow can step in and finally get something recorded that says this was paid off. And we have negotiated with the various industries, and the bankers are comfortable with the procedure so that nothing will get released of record without their opportunity to object that it was not properly paid off. Respond to any questions if you have them.
Hey, Bob.
Mr. Chairman, Senators, I'm Bob Mitchell representing the Washington Association of Realtors. I will keep my remarks very, very brief. We have now been here several years asking for this particular piece of legislation to be enacted. We believe that it does address a specific need and will in fact minimize the number of times that previous owners have to initiate quiet title actions in order to get their title cleared. We believe that it's good common sense, and we would ask for you to please move the bill this year.
Senator Benton?
Bob, it's not always a bank. Sometimes it's an individual, right? Whoever actually holds title to the land now. And so what I'm hearing you guys tell me is that we've been allowing citizens to be ripped off by whoever, bank, somebody that owns the property, whatever, people that took their money but then did not release the title of the land. We had a bill earlier this year on 1031 exchange companies that did that, and we cracked down pretty hard on them. And so I don't see any reason why this legislature shouldn't crack down on thieves that steal people's property, that take their money and don't give them the title after they agreed to the deal. So it sounds to me like the bill's long overdue. How many of these cases do we have on average? Does this happen very common? You said you've been here for years trying to pass this, so it's an ongoing problem, obviously.
Well, I've been in the state for 30 years, and I regularly, at least once a month, have a circumstance where a seller is stopped from a closing because there's a deed of trust and they can't get it reconveyed.
Unbelievable.
And all we can tell them is, you need to figure a way to contact that lender. Well, we can't. It's WAMU. Well, find someone at Chase that's willing to admit that it was paid off. You can't. It's overdue.
Amazing.
I love it. I love it. Find someone at Chase that'll step up and help and do the right thing. This is just an outrage, and this is why I'm telling you it's getting infected, because there's more and more and more. Lenders are out of business. The banks don't do what they're supposed to do. It's really obvious. And here you have this right in a state, Washington State, where they have what I call true limbo land. The buyer wants to buy, the seller wants to sell. They can't do this because they can't get clear title, because the past isn't reconveyed. It isn't taken off the property. That debt isn't removed. And did you hear what they're having to do right now? They're having to get the sellers, after the fact, to go into court in a quiet title action to get that removed. This is just insane. This is an outrage. Now, I wanted to play a little bit of a clip from an objection to this, and this is classic because he's objecting to the bill, saying that if they do it, nothing will sell. Gotta listen to this piece.
Thank you, Mr. Chair. Stu Halson here,
Same
now
discussion.
representing the Washington Land Title Association, and I just wanted to bring up a few things in response to what we just heard. This is not about foreclosures of deeds of trust. The talk about mediation and foreclosure counseling and all of that type of thing is totally irrelevant to this. This is not about anybody losing their home. This is about somebody wanting to sell their home. They want to get the documentation so that they can sell it. And this bill merely sets up a default system of notices and filings that can be used when the beneficiary, lender, and trustee don't do what they're supposed to do. You know, a lot of the stuff that you just heard, you know, Danny may not like this, but we're dealing in the title industry with the environment in which we're in. One of your last witnesses talked about securitization. Yeah, that probably is the problem that really is concerned with them, because Wall Street securitized a lot of these mortgages, packaged them up. They're owned somewhere off here and somewhere off here, and the collections are run by a servicing agent here. You know, we've never required, and this law doesn't require an original note to be done in order to do that. The current statute doesn't require that. We're releasing collateral. We're not releasing the note in regards to this. You're not going to be able to change what Wall Street did with those securitizations of all these things. So we're dealing with the situation on the ground, how we're trying to sell your houses. And if you start requiring the original note that has been gone through, I don't know how many hands, but the collection is being done by a servicing company that we know, if you require that original note, none of you will ever be able to sell your property. You just won't. And that's my weak understanding of this thing. But this bill has nothing to do with the problems that really seem to have these previous witnesses worked up. We're just trying to get these transactions through. And I would remind the committee members, we're title insurance companies doing closings. We do this closing and you sell your property, we're insuring the person buying it from anything that might be a problem there. And this bill only releases the lien. If there are any lawsuits or whatever that might come of transactions that they talk about a fraud, those can still be used. It's just the property gets to be able to be transferred. All those other potential suits out there still exist, if in fact they're there. So that's my weak, perhaps, explanation in response to what we've just heard, and I'll defer to Denny and Holly.
Classic. Did you catch that? Did you catch that? If they actually required the note to release the lien and to be able to do the transaction, nothing would sell. So we have experts giving testimony to the fact that this securitization is a complete mess and a nightmare. And the facts are these. They don't do the job. They don't release the collateral. This is the fear now that's growing amongst people that are paying their loans, because they're listening to what we're saying, and they're saying, well, wait a minute. Am I sure that my payment is going to the right party? What do? They contact me. I'm not even in any way, shape, or form close to foreclosure. What should I be doing? I'm telling them, send a qualified written request and do it right now. Demand right now that your servicer is correctly applying all of those payments to your loan. Or if you're going to pay that loan off, I've got someone that contacted me about that who was scared to death. I think the servicer was Aquan. And so this person came into some money and said, okay, I want to pay off my loan. So she calls Aquan, the servicer, and tries to find out about how to do that. By the time she's shifted around the planet and ends up in the Philippines with some person on the phone, there is zero confidence that if she sends money to somebody, that it's going to actually reconvey the debt. And this is the point. I believe that she was told it would be at least 9 to 12 weeks before they would reconvey the debt. And did you hear that? The fact of the matter is, the banks won't reconvey until they're paid. So when a person buys in the transaction, the seller has a debt, the buyer's money comes in and pays that debt off, but that lien is not released on the property until weeks later. And sometimes they can't get it released because the escrow has no clout. They have no law. They have no other way to get that released, even though they know it's been paid. And this is a true dilemma, because it's in the bank's vested interest to not release the loan. So this is where we're caught. We're now caught in the middle of servicers completely reneging on their duties, and nobody has the tools with which to force them to do it right. It's truly a breakdown. It's a breakdown in the system. So today I'd like to jump into quickly, how are we going to get the courts to work for us? And I think Renee's on line one. Let's invite her to the show. Hey, Renee, this is CJ. Is this you?
Hi, CJ.
Hey.
Yeah, it's me.
Oh, good. Thanks. All right. So share with us today what you've come up with as far as how can we, maybe do something different now in the court, use the courts differently so that we can get them to work for us instead of always just getting booted out.
Exactly. Well, this has been the conversation with many of us, and we keep saying, gosh, disclosure, and they're not disclosing anything.
Right.
And when you go 10, 15 times to court, and the judge doesn't make them disclose anything before ruling. So we know that disclosure is a huge issue. And I was speaking with Ronald O'Donnell, and he is very passionate as I am, so you get the two of us on the phone, and oh my gosh, it's hysterical. But,
and we all benefit, and Ron's coming next, so thank you for doing this.
So I told Ron, I said, my title is not only clouded, this goes back to my grant deed, and I've been asking questions of grant deed, and he said, well, are you willing to do something about it? I said, well, no, shoot, Sherlock, that's, yeah, I'm willing, I just don't know what to do, and he says, well, what about a small claims action? And I said, well, what about it?
Right.
My wife wouldn't explain to me because I've asked about small claims too and didn't know. And so what we brainstormed was, the fact is, I know it goes all back to even escrow. That's where our documents come in for all these transactions, escrow and title. And title will not help us when we call them and say we have clouded title issues. People are having trouble getting title to help as well. So he says, well, who did you buy the policy from? And I said, well, I paid escrow. And he said, bingo, so let's file a small claims against escrow.
Okay.
Fault on your insurance.
Okay.
I said, well, shoot fire, that makes perfect sense. If I was to buy anything from someone and there was a default or a breach of a contract, you go back to who you paid, correct?
Right.
So I paid escrow. So we now, yesterday, and the simple thing is, this is how we get the courts to work for us. When people say, how do we get the courts to work for us? Bingo. This is how you get the courts to work for you. In small claims, those big attorneys with all the fancy suits and ties can't come in.
Right. It has to be the owner. So here's the next question, and I've got up on the screen right now the order to go to court. This is the a plaintiff claim and order, so that people can start getting familiar with the forms, and then you can talk us through them. So the fact is, when you sue them, who is going to show up? You're going to be there, of course.
I don't know. That's their problem. I'm going to show up. But what I'm going to do when I show up is ask for mediation, not court.
Right.
I'm going to ask to mediate because we don't want to go into court. We want to understand what I bought. I want them to prove to me what I paid them money for. If, in fact, I'm not getting help, why not? What did I pay you for? I paid you for a clear title. I paid you for insurance that what you were doing here at this closing table is not clouding my title. I paid for that, so show me what I paid for. So what I want them to show me is what I paid for. Show me what you did and all the documents that I paid for. What did I pay to insure? They have to disclose that. They bring those documents in. That's their proof of what I paid for.
Okay, now here. Okay.
So what I did here is Ron and I sat on the phone with him, and we went through this. I went to the Orange County court site because now everything has to be done online. They don't want you coming into the office.
Right.
Okay.
Figures.
So, and I was shocked at how easy this was to do.
Right.
I went online, filled everything out, and it took me 20 minutes just because Ron and I were going back and forth discussing it. It really is only, it takes you less than 10 minutes to do this.
And I'm showing them the instruction page. There's an instruction page included. Yeah, and explaining what these mean. So
It tells you, and it goes step by step. It is literally a fill in the blanks. We kept it as simple as possible because that's how you want to keep it. You keep it simple, sweetie. The old adage.
Right.
Simplicity. We are there to strictly say you defaulted on the insurance. How did they default? Well, I paid them for it. So if I paid you for something and somebody's not following through, I want my money back. Or I want you to produce why you don't owe me money back. I want your proof as to what I bought and trusted was going to protect me and protect the title on my home. Remember, the very grant deed that they took was executed in April, forged with names on it that did not exist in April, and then filed in court, in records. So I'm asking, this is all supposed to be covered under what I paid for.
Okay, so here's
I want them to prove to me.
Here's a question, because this is just an ongoing discussion, and all these questions pop up in my mind. One of the things I think you commented already that you've already tried to get them to work with you, and they won't do it. They won't respond to requests for discovery. Is that correct?
Correct.
Okay, and the judge didn't force them to do that.
Oh, no. I'm not in court over this. This is all done verbally with them.
Oh, just verbally. Okay. All right. And so you keep
I'm not
asking.
in court. This is all to keep us from small claims is the place to start, in our opinion, from what Ron and I discussed yesterday.
Right.
Andy also was in on this discussion with me this morning. John Stewart talks about small claims.
Right.
There's many people saying this is the place to start.
Exactly.
Small claims, we have the power to show proof and truth because they're big, fat butt attorneys who come in there and lie.
Exactly.
Mouth just vomit lies.
Right.
Can't do that to us in small claims, and it's legal. It's within our right. We have the court works for us at that level.
Now, here's another question, because I have right up on the screen right now that you're asking for $9,900. Is that, how did you come up with that number?
Ron and I came up with that number because the most you can do is $10,000.
Right.
Now, remember, I'm being very specific. I'm just doing the default on the insurance. So people are going to say, oh, my gosh, you do this, then you're not going to be able to go forward with any other lawsuits or any other claims against these people. That's not true.
Okay.
Have to do it properly and be specific. I am going after them because if they're not going to, if I'm not going to be able to use what I bought from them,
right,
then I'm harmed and I'm going to have to hire an attorney to do it. So I'm claiming that if they have breached, when they have breached their agreement to sell me something that actually does what it's supposed to do and isn't, then they're responsible. I not only want my money back, but I want the damages that it's going to cost me to hire an attorney.
Right. So, and then the damages, hiring an attorney, if they're not going to help you, if you will, clear your title, is that really the point with their title insurance policy? Then you would have to have either yourself or, some expense to go in and evidently do something like a quiet title action. Is that how you would proceed?
Could be. Basically, what I'm looking at is we're doing a tier. Escrow is where all the documents went into to be signed.
Right.
Escrow title issues then were to follow with the title insurance company.
Right.
So after I'm done with escrow, the goal is to then go file a small claims action against the title company.
For
same thing.
For what?
For default of insurance.
Okay.
Not following through. And see, now I also had an issue, remember, with 2 illegal trustee sales, where I had someone else on title.
Right.
And the title company told me they would not help me until I was back on title. Well, I sent them proof that I was awarded the title. Now, what you just showed, as far as people who have title that aren't put back in their name, etc.
Yeah.
That was the issue that the title company was using against me. And Ron was very clear to me. He said, no, you bought title to insure your title. You gave them proof that you are title holder.
Right.
The fact is that they have not complied with the reconveyance in writing, but you have the writing to take to the court to prove you actually own the property.
But see, isn't this is exactly just another phase, another facet, another discussion of what we just saw this morning from Washington State as they consider a bill. The title officer, the escrow officers are coming up and saying we can't clear title because we can't
and that
get
just
cooperation.
Proves the wrongdoing. That
Exactly.
proves to us and proves to anybody listening that everybody knows that if title is clouded, that we have nothing, they have nothing to collect on us from. There's zero owed, and that's a whole other
issue
out of a debt
Right.
collections day discussion. But since
Right.
there's zero owed, and these people are out there using title against monies that do not exist and trying to take title to something that they do not have a debt for,
Right.
it's just all convoluted. So it all goes back to, in my thoughts, and what we discussed yesterday was right back to escrow. Hold them accountable for what they've done, because they are accountable. They're accountable for the documents they take in and forward to title. They're accountable to us for the fact that we paid them for a title policy on the HUD. It's there. What
Right.
else did I pay you for? I
Right.
paid for homeowners insurance. Show
Right.
me what I actually paid for.
Right.
You told me I was being protected when I bought this.
Right. And of course, we all know that by not reconveying the loans, the banks win because they can continue to re-securitize that and play with it, sell it to somebody else.
Exactly.
And
What we do here is we hold them accountable to giving us the evidence of what we need, so that when we then go against small claims against title, they have to disclose to us. Now remember, in title, you also have remitters showing who's paying in and who's paying out. They don't want to give us those. That's why they do not want discovery, because once you have those documents, it is proof that you didn't deal with who they fraudulently told you were dealing with.
it proves the real owner who really got paid, whether they were owner or not. Right?
This is how we get the evidence. We force them with the court's assistance in small claims through mediation. We are making the courts work for us, as we all have required and demanded, and they took oaths for. We now know that they have not taken an oath for us when we go into that judicial
Right.
court setting
Right.
with those judges, those administrators.
Right.
They're only there to collect money. They are not there to help us.
Right.
We are the
Right.
enemy. We are the
Right.
beast. Remember, when
Right.
you look up those words in Black Law Dictionary, we are not the ones they're there to help.
Now, here's a question. Sorry to break in. So you've filled out this paperwork. So what are you going to do next? You're going to file this, or have you already filed it, or how?
Oh no, it's already filed. The court did it, and it shows where you pay, and they do the certified copies and the service.
Okay, so I want to show
My
those.
computer, within 20 minutes, with Ron and I going through it, simple. We filled everything out. We put in the addresses. We clicked everything that needed to be done. They then send you to a page that says, do you want certified copies done for you through the court? Well, heck yeah, they're going to supply the service for us right there.
Is that a fee? I mean, what did this cost?
There's a fee for that, but there's also fee waivers. Don't forget, if we're out there as homeowners without the kind of income to generate payment for all of this, you can do fee waivers too, which is very simple. You go right on there, and it's another click, 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 click. So this all is done from your home, in your chair. Finished it within 20 minutes, and they, in 3 to 5 days, they send you back your, you go on in 3 to 5 days, it tells you to look at your stamped documents, which will then have the court stamp on it.
Right.
Give you the court. And it also says in there, oh, by the way, do you have a preference for court? I put night court. Because it's easier for me to do night court, so I put a preference in for night court. I'm not making this easy for anybody I'm taking in to sue.
Right, exactly. It's make it easy for yourself. So if you're working, night court makes best sense. Obviously, you're suing a business. And now I noticed, I was looking over this while you were talking. I had up on the screen this is the certified mail statement. And the clerk will attempt to deliver your claim as addressed. And so you pick the name of the authorized agent, or partner, Sheila Knight. Where did you get that person? Was that from the
Sheila
HUD
is
statement?
actually a really nice gal. She's the one that helped me at escrow and walked and did all of it. She's the one that actually handled all the documents. So I'm going to give her actually a courtesy call to let her know that she was the only name I had, so to pass it on to her boss, because this has really nothing to do with her. It has everything to do with the company.
Right, exactly. Okay. And so now they're going to send this out, and then what happens next? Do you know?
Then I get a court date.
Okay, you get a court date.
And then Ron said he'd go with me.
Okay.
Because we really are doing this as a prototype to see what needs to be done for other people. Because we're
Exactly.
all tired of hearing, what can we do? Well, heck, if we don't all try something,
Exactly.
it's going to be noosed. Our necks are in the noose right now. So let's get the noose off of our neck, put it back where it belongs on theirs, go to small claims, watch, just Ron and I are doing this together, and he's helping me. So let's see where this takes us. Let me be the trial and error of what is procedurally going to help. And and the other thing is when people say, "Oh, the negative Nancy's out there," anybody who's a negative Nancy and doing zero other than running your mouth, I say quit talking, because we are trying to find solutions. If you're not going to help find solutions, be a problem solver, not a problem maker.
And
attacking people who are doing things, then we must
Exactly.
be doing something right.
right. And we have nothing against people named Nancy. It's just a
Yeah, I
term.
know. But that, you know what
Yeah,
I mean. Oh gosh,
I do.
politically correct.
I
They're
do.
here. There's
I
nothing
do.
politically correct anymore. Look what they've done to us.
I know.
That,
I know.
That what you just showed.
Exactly.
Proof evidence. Those people sitting up on the podium acted shocked that the big banks don't do reconveyances. Seriously?
Yeah.
Shocked? What are they, living in a damn hole driving their Bentleys?
Well, yes.
Something's not right.
Yes, and that is the problem. The people that make the laws, I think, are so insulated. They have a government job, they have a government pension, they have a government, health plan. Everything's all covered and paid for. So they're not really in the real world, as the people
and
are.
I just had a question come up. Tuna just asked about late pendants. Yes, we're going to be filing late pendants, and with that
Okay.
late pendants, I'm going to put on the OCC complaint and every complaint I've filed and attach it to that late pendant. So like Ron said, well, I can't tell you what Ron said, but how Ron meant it was that we are going to put all those anybody on notice that pulls up my title and looks to fraudulently try to steal my home again, that we are out after every single person who has touched, will touch, try to touch, or attempt to steal my home again. And so this is the whole thing there. The late pendants, yes, we are going to work at that. That's my homework for today from Ron. So we'll do that, get everything attached. In 3 to 5 days, I will get the proof of everything ready to go with the court date and everything stamped on it. But the late pendants can be filed because it's pending litigation.
Exactly. I've got it up on the screen right now for those of you that aren't familiar with the term. It's LIS, lis pendens, Pendens, and it's a Latin and means a lawsuit is pending. Now, in the normal transaction world with normal buyers and sellers, if there is a lis pendens filed on the property, no buyer wants to buy it because it's a clouded title. There's something going on that might be negative, and so it stops transactions. However, I've noticed that people have tried to have filed lis pendens on properties that are being foreclosed, and the banks don't care. They don't care. So it doesn't really work. They're going to foreclose anyway, and they'll sell it to somebody else, and they'll lie to them about it. But in your case,
so whether people may say they don't care, and the banks may be doing it anyhow, but remember, this is the foreclosure mills.
that's right.
Don't care.
That's
If
right.
this isn't going to come back to them,
Exactly.
done their job. They're getting their money. They don't care. But if a late pendants is on file, and we are smart enough now and learning enough and being educated enough to know to fax that to the actual trustee, to the actual people that we have any connection to, they will care, because that's going to come back to them. The foreclosure mills, when people don't care, you know they have no skin in the game, which is more proof to the fact that these foreclosure mills have no legal right to foreclose. They have no skin in the game.
You're absolutely right. You're absolutely right.
So,
Yeah. Because if they had skin in the game, they wouldn't be doing this.
No, they're foreclosing because
Yeah.
they're the only ones making money.
That's right.
And they don't care about anything on file or on record because they're the
Right.
ones creating the fraud.
Right.
They know they put everything in there because who is going to ultimately be responsible? The lender, fake,
Right.
trustee,
Right.
fake certificate holders, because we all know there's no money owed anywhere. Certificate holders are the investors who've just sued and continue to sue. We know the trustees are not able to do anything because the PSAs prove that. So how do we make forward motion? We get into small claims court and take those baby steps, because there's one thing we all know. Who controls the house when they're born? A baby. Revolves around that baby. So let's go to the baby court, small claims court. Why? Because they know, and now we are getting it, small claims court's going to work for us.
Right.
We
right.
just gave birth to an answer.
Now, here's a question I've got for you, Renee. And I'm showing the small claims order again, and I have not had a chance yet to upload these to the website. But I'm going to do that and make that another item in our strategies that we can use for fighting back. And what I wanted to know, or what I want to ask, and I know you're just doing this, I'm going to see what happens, and we so appreciate it. I'm guessing, I'm going to predict that they don't show up. And so if they don't show up, if you get nothing out of this, does the judge then give you a judgment for the $9,900?
Well, yeah, if they don't show up, I win. Period. So there is no loss here. Think about this. They don't show up, I get $9,900 judgment. They owe me $9,900. That money then will help going forward.
And that's because you said so.
And they can't do anything else. They have to pay these.
Right.
This is a debt they have to pay. So that's another thing. They don't show up in court. They don't pay me. Now I can go after them further. And I can sue them for more.
Right. Because now they're definitely demonstrating they don't want to give any information of that to you. And
because I'm not asking to go to court. I'm asking, I want to go to mediation. I want to sit down with you, look you in the eyes, and tell me why and what I paid for. Why did I pay for this? What did I pay for? I gave you money. You did all the paperwork. And this isn't the escrow officer. We got to remember this. These people now are understanding, and I believe are more responsible, because this is all coming out. If you are an escrow or title, you're listening to this stuff.
That's right.
You don't want to be taken into court. But guess what? Neither did the attorneys who were working for the banks. And this is why we're segueing into Ronald and his discussion, because right now, what we are doing is we are taking things, we're grabbing out what we can problem solve. We're just problem solving. And anybody out there listening, if you have just had an aha moment, oh my God, small claims, yes, but add this part to it, and it's going to make it stronger. Or file this with it, and it'll give you more strength. This is what we're doing. We're networking ideas.
Right.
And unless we network ideas together,
yeah,
everybody across this nation is looking for answers.
Exactly. How are we going to fix
it? The network, come together, give information. Send CJ information. If you have information that will make this even stronger, or give us another direction that's factual, has been used, send cases. If there's a small claims case out there that you know of that's already done this, which I would have to believe somebody has. So please, send them to us.
Exactly.
And get strength and gather strength for the masses here. That's what our goal is. And that's why what Ron is doing, holding these attorneys accountable,
yes,
our next step. And why are we doing this? Because we all know these attorneys working for these banks, and I know you're out there listening because I've been told. So you're out there listening. Listen to us. You have the ability. You know where the bones are buried. You know everything that these banks have done illegally. If you're working for Bank of America out there right now, flip-flop, help a homeowner who's suing Wells Fargo. Yes. Unless you know what we tend to believe, that you're all owned by the same damn conglomerate.
Exactly.
If that's the case, you can't work any case. But if that's not true, which they keep telling us that's not true, then prove it. Go help a Wells Fargo homeowner who's struggling against the fraud that you know is out there.
Exactly.
So let's go from small claims. Let's listen to Ron, and this is what's going to help us win, folks. Get out there and hit the pavement, do things, and know that you should not be afraid of trying. If you're not lying, they are dying.
Right. Right. I wanted to thank you so much, Renee, and I wanted to point out one more thing I have up on the screen right now. On this form, it says, I have not filed and understand that I cannot file more than 2 small claims cases for more than $2,500 in California during this calendar year. So that makes it sound as if you could file multiple more than that if they were less than $2,500 each. Question number 9 says, have you filed more than 12 other small claims within the past 12 months? And of course,
so basically, we start out at 9,900.
Right, there's one.
Keep it 9,400 or 2,400.
Right, right, and right, exactly. So it looks as if you could have 2 claims over 2,500 in a calendar year, and then 10 other claims less than 2,500.
Right. So my first 2 claims will be with the. And this is why this is empowering, because even the courts know that if, say, a business needed to sue someone, they may need to sue multiple people or multiple times in order to get what they need. So they have the court set this up as a collection, thinking of the court. But guess what? It works for us too.
Right.
You can do 2 over 2,500, and then do 9 more under 2,500.
Exactly.
But you just have to use what they are. This is a tool the court has for us to use. Let's use
it.
Them to get our evidence and to go forward. These are breach of contracts.
I view this as a leveling field. This is the people's court. This is where people can go in and they have to deal with people. So we can cut out the attorneys. I'm sure that somebody from that escrow company personally is going to have to show up, whether it's the lady you mentioned or somebody else. Right. If they show up.
And they can't be an attorney.
Right. If they actually show up.
Remember, they do have a right to ask that this be taken into Superior Court so attorneys can show up, which would really be interesting because that's going to open up more cans of worms than they would ever want. So I would not believe that that would be a route they would want to take, but it's going to be interesting to see if they do take it.
Exactly. And just because the way you get treated doesn't necessarily mean that's the way everyone's going to get treated. We just don't know.
This is all about everybody understanding.
Right.
We're willing to make these actions to see what it takes. And we know I need to do this anyhow.
Right.
We need to do things to help ourselves. So I'm doing this as a, what the heck, I've got to do something.
I might as well try this.
Yep.
We so thank you, Renee, and thanks for sharing. We've got Ronald on the line. Let's segue into what he's going to bring to us today, because I know he's super angry, and Renee's already given us a little bird's eye view about going after these attorneys that are facilitating, my word, these forged documents in court. Thanks, Renee.
Thank you, CJ.
Keep us in touch. Hi, Ron. This is CJ. Is this Ronald?
Hey, CJ. How you doing?
Fine. How are you doing?
Listening.
Okay, so Renee is, telling us how she's willing to I call it a lead dog. She's willing to take these ideas and run with them and try them both for her own help, and if we can set a pattern that others can follow, more power to us. So,
I just want to say something.
Sure.
Even though Renee called me a pothead, I can get over that.
She called you a what?
A pothead, she called me. I went to Grateful Dead concert.
I see. That's okay. We love you.
I love about this group that you have, CJ, is we're from all over the country now.
Yes.
And we're listening to you. And I'm asking everyone I know to listen to your show. Oh. And I mean attorneys also.
Yes.
All right? Law enforcement officials. And I hope you don't mind that I'm giving them, Homeowners for Justice website.
I appreciate it.
That's okay with you.
I appreciate it.
Because I'll tell you what, especially what just Renee did right now, I could never do. I don't have the ability. I don't have that communication skill that she has. But my hat's off to her today.
Well,
I love everything she said. Now, I just want to tell you, I'm a teacher, I'm an educator, and I'm retired. And I'm licensed by the state of of California Department of Education with a lifetime teaching credential in all real estate subjects.
Excellent.
And I taught over 600 real estate salesmen and brokers in Orange County, California, 77 through 84. The Saddleback Valley Community College. Anyone that wanted to become a real estate broker, I taught all the subjects. And they can never take my license away. So what I'm telling everybody out here, they're on assignment. And their research project is discover these banksters that are stealing our homes.
Yes.
That's my assignment that I'm giving everybody listening. It's official. You're my students on just some tiny little subjects. And CJ, you have to run with this. I'm working for you. I mean it. We're not getting paid, none of us.
I know.
You're the boss. You call the shots. And all I can say is I'm so proud of Renee. She did a better job than I could have ever done. But I want to say a couple things, just, briefly, just on the way out the door here. For anybody listening, what I've done is I've taken them to small claims court. I went to the mediation, and I dragged it on and on and on. And all I wanted to do for my $65 filing fee was get the information, get the documents, get the escrow documents, get the title insurance policy, get the original homeowner's insurance policy. And then we'd get to the point where I'd ask for the promissory note that was countersigned by the bank, and that should have been in the escrow before the escrow closed, and they don't have it.
Just a minute, Ron. So you said you went into small claims court already, and used
in many states.
And you used that to get the information. Basically, it sounded much of it sounded to me like a qualified written request.
Well, what I did was, once you are in small claims court for $65, you're allowed to. You have subpoena power. You're allowed to list a list of interrogatories. You're calling it a qualified written request.
Right.
Actually, legally, it's an interrogatory.
Right.
Instead of calling it a qualified written request, just wipe that out and put first set of interrogatories.
Oh, my goodness.
Petitioner in any court has subpoena power. You're not powerless, is what I'm trying to tell people.
Now, here's a question.
You have the right to demand, not request, answers to the interrogatories. You have the right to demand that they produce the documents.
Now, did they produce?
Well, yes, they did.
Up to a point.
I stuck on it. I would not let that go. And then, just for everybody out there, when they brought in all their attorneys and their experts, I just walked in and said, Ron, I'd like to go ahead and file a motion to dismiss the case. And everybody fell down on their chair. They had like 10 people against me, because they had to get permission from the court to bring in all these other people, expert witnesses. And then when I saw that I was being overloaded,
right,
I just dismissed the case and turned around, closed my briefcase, and walked out. Because I have the power to open it, and I have the power to end it. The petitioner, the complainant, has that power. The homeowner has that power. The homeowner has power to go ahead and issue interrogatories on their own. They don't need an attorney, no judge's permission. It's by statute. The homeowner has the power to demand the documents. No permission from the judge is required. No permission from the defendant is required. It's by statute. You have subpoena power. The homeowner has power. We need to teach the homeowners the powers that they have. They keep thinking they hire an attorney and the attorney has power. No, the attorney is merely an agent that derives their power from the homeowner.
Yes.
They're acting as on behalf of the agent. They don't want you to know that.
Of course
they
not.
want us to think that the courts belong to them, and I'm here to tell you the courts belong to the homeowners, to the citizens of the United States of America. We built those courthouses for us, not for the banks.
Right. Now, here's a question.
Told you I didn't want to rant.
You're doing great, and I'm just full of questions because what you're saying. I can tell it's very powerful, and we're going to do what you're saying. We're going to start teaching the homeowners this, and we're going to start doing whatever it takes. Trust me, I'm already working on that.
I want 1 million homeowners to file
absolutely
a small claims action
absolutely
against their escrow company where they bought their home. And if they don't have the money to file, it's free. All they have to do online is fill out the portion where they're in pro paupus, is what it's called.
Right.
And the court will waive the fee. They have to by statute, not because they're your buddies.
Right.
It's part of the law.
All right. So I can...
I'll shut up.
No, just answer my questions.
Right.
I can already tell you, and people viewing, that in my head, I see now a list of the questions, where we go first, how we make sure that we keep our small claims court filings within the limits that are set, so that we can get the information we need. If they don't show up, we get payments, and we can use that to build a fund to fight to keep the house. And Ronald and I, obviously, we're going to be going over this step by step so that we can bring that to the public, because definitely the fact of the matter is, and I already know it, I've represented hundreds of clients and looked at thousands of homes. I mean, I've done brokering with the public for a long time, and it's told me, I mean, I just now know intuitively because of the experience and by listening and paying attention and caring about the results for the parties, what the people want. I know what the people want, and I know how to sell it to them once we can get a solution. And this is what we've been doing. I'm just so proud of you guys that you're stepping up, bringing this expertise into the mix, because I can't do it myself. Ronald can't do it himself. Renee can't do it herself. None of us are nearly as powerful on our own as we are together. And that's why I'm saying the homeowners, we must rise up. And when we do, and these ideas come to play, we're going to figure out how to solve this crisis. And make no mistake, it's a major crisis. It's now starting to infect this clouded title disease. It's like a virus, and it's going to literally affect all the properties in the country. It's already affected the records. The records are already filled with forged and fraudulent documents. So how can you have clear title with that? The law and the courts and the statutes say you can't. So what Ronald is doing is I believe this is a classic case. I'm just so thankful you've been working with Renee on it and that she's a lead dog on this. And that is truly what I call a grassroots. This is grassroots effort. We're going to the people's court at the low level. And just like I looked at the documents, just on the face of the documents, you can go to the recorder's office, get the documents, and you can say, gee, that signature is forged. Gee, that servicer took ownership, and that's illegal. So
but in the little courts, you're allowed to go ahead and show them the fraud.
Right. So this is really great. And I had some other things that we thought we might talk about. We're sort of running out of time. We'll talk about them later. About the the whole system is fraudulent.
To the United States Department of Justice.
Yes, thank you.
3 complaints.
What? Okay, you sent them to who? Eric Holder, or who did you send them to?
Okay, every district has a U.S. attorney.
Okay.
For example, I sent it to the Western District, the Middle District, and the Eastern Districts of
Why did you pick Pennsylvania?
Well, I'm representing a guy, 86-year-old doctor, who happened to be a lifetime friend of mine. He was my mentor for the last 25 years. 86 years old on chemotherapy, and they're trying to foreclose against his house. And we bought off 3 different foreclosures already. I have the records and fraudulent documents. Fraudulent, forged, and intentionally altered documents were placed in the records, and that's a violation of 2 things. RICO, Racketeer Influence and Corruption Organization Act, and secondly, the Civil Rights Act. Age discrimination, 86 years old. Those are the two things that the U.S. Attorney is charged with working on.
Right.
Don't do state matters. But when a state matter affects federal rights, they are now involved, whether they like it or not. And I just reported the fraud.
So you just sent this information to them. What do you expect to happen?
I want to put the banksters in jail, or the attorneys.
I do too.
And the judges.
But what do you think?
In prison.
Do you think you're going to get any response or any?
I know I will, because guess what? If I fraudulently put something on the record, say I could sit here right now and I could sign that my house is paid in full, sign a reconveyance, fraudulently put it into the record.
I know.
And the record will reflect that there's no money owed to anybody on there.
Right.
But it's a fraudulent document.
Right.
So I go to prison if I would do that.
Exactly.
But I could do it right now. I know how to do it.
Exactly.
I could sign a reconveyance right now, to me.
Right. Right. I know.
It's fraud. Well, guess what? When an attorney puts in a fraudulent document, he's doing the same thing for the bank.
Okay, so you are going...
He doesn't go to jail, right, because he's immune? I don't think so.
So
he doesn't go to jail because he has, he's an officer of the court? I don't think so, and that's why the U.S. Attorney has to be involved. We have attorneys that are filing fraudulent documents. They have foreclosure mills. You know, we're all blaming these little notaries. Hey, they don't tell you that they're sitting in the attorney's office and they're told by their boss to sign the fraudulent documents. So they get the heat. No, I want to take it up a level. Let's go to their boss that told them to sign the fraudulent documents.
So now, in this case, did you identify specific attorneys, like at the foreclosure mill firm?
Yes, I did. I actually sent 450 pages of documents attached to my complaint with evidence all the way from Lorraine Sanders in the eastern United States all the way to western United States, Dr. Salim Malatrash, and gave them specific examples of everything, and they're idiots if they can't see it.
Oh, I don't believe they're idiots, and I believe they see it. I already
know, but now are they going to do something? Let's see.
That's the point.
It's
Can
on
we
the
get
record.
them to do something?
It's on my list penance.
So let's say that they ignore you.
They're not going to.
Okay, they're not going to, so they're going to give you some response.
It'll be on the news. It'll be, and I'm going to put it right on air. I just put it on C.J. Holmes, Homeowners for Justice, and America's looking at this. People are listening. People know now, and you cannot hide anymore.
Well, and that is the point. This is the major problem that I can hardly bear it. People will ask me to help. I will look at their documents. They have complete fraud and forgery, and yet the bank is going to take it. The foreclosure mill is going to just sell it at auction and take it. They don't care. It's like a headless monster. We can't stop them. It's completely run amok. It's mind-boggling. And that's why we're constantly focused on, okay, how can we stop the machine? How can we fix this? Because first we have to stop them. We have to stop the theft. And then it's going to be an issue. We're going to have to really focus on how can we fix all of these clouded records and all of this mess that they have made, because they've really messed up the records of this entire country. And
what I'm appealing to my government to do for my homeowners, my citizens, my fellow citizens across this country, this great nation, I'm asking our employees that we pay them our taxes to do their job. They're all making $200,000, $400,000 a year. To please go to work, earn your bread, off your ass. You might be a U.S. attorney, but when we were in the gym together and we were taking a shower together, okay, you took off your clothes the same way I took off my clothes.
Exactly.
You're no better than me, and you're no better than anybody else, another U.S. citizen. Let's get this on a level playing field. We know who you are, and, cut the big shot stuff. We don't need big shots stealing our homes. In fact, we need to put the big shots in jail.
Well, I truly believe that if and when we can get some entity, either the Department of Justice at the federal level or a state attorney general, like a statewide grand jury, like I'm trying to push the prosecutors in that office to start, and they start looking criminally at these foreclosure mills.
This isn't civil. This is the U.S. Department of Justice. They only handle criminal matters.
I know, but only when they start.
Civil litigation.
Only when they start looking at them criminally are we going to get anybody to stop. Because otherwise they just make the company pay and they just go home and enjoy their pension. You know, they don't care. But if they know that they're
don't want to get involved.
Yeah.
You know, because if they can avoid it, they retire.
Exactly. Exactly.
They don't want it. But they can't deny it anymore. And the more there's C.J. Holmes speaking and speaking and speaking and getting the word out. C.J. Holmes, Homeowners for Justice, across America, hundreds, thousands,
That's
millions.
What we need.
That's what I want.
That's what we've got to have. We need 1 million owners stepping up. And I'm telling you, Ronald, I think you and Renee have hit on something that many, hundreds of thousands of people are going to say to themselves, well, I could do that.
Yeah,
and that's what we want.
Small claims court.
That's,
Start somewhere.
I can afford it. I can do it. I can understand it. Thank you for the training, and move forward with it, especially if we have several people in the same area, then they can work together. You know, it's one thing to just step up all by yourself and try to do this stuff, and it's scary. Nobody knows how it's going to work. So thank you so much, Ronald, for working with Renee, going with her to be there, helping her, guiding her, figuring it out for us. We just so thank you for that.
Can I say one thing before we leave?
Yes, please do.
I'm asking anybody that's listening, if you really have the passion that Renee has, to get on the phone tonight, call 3 of your best friends and ask them to listen to this show tomorrow. Just say, listen to the show tomorrow. It's going to get better and better and
Absolutely.
better. I learn one thing every day when I listen to this show, and that's with 8 years of college. I learned one little thing, just one tidbit. I want everybody to get on board, get their friends to start listening, get them involved. Don't just sit back and do nothing. This is a great place to start. And with that, I'm going to say thank you for listening, and I'm going to go ahead and hang up, CJ. And God bless everybody, and God bless America.
Thank you, Ronald. We just so thank you for your participation and for your energy and enthusiasm and help and guidance, because this is what the people need. They're looking for some leadership and they're looking for answers. And I can't even begin to tell you how much I've learned just by doing the show. It's been fabulous because I'm listening to every show. I'm watching every show. I'm here. And people are sharing such incredible information. I truly believe that we can make a difference, and we will. We can't give up the fight. And I don't think we need to. I think that people just need to feel empowered. Most of the people...
empowered. They just don't know it.
That's right. That's right. That's right. I appreciate it.
They are empowered. They're the only ones that have the power. The attorneys have no power. The judges have no power.
That's right. It is from the people. And it's even all the rules and laws of the land. All of our representatives, their power comes from the people. It doesn't feel like it a lot of time.
We'll get them out of there.
Exactly. Exactly. Thanks, Ronald. We're going to sign off. We're going to sign off. Thank you so much for joining us. And I did get an interesting little closing song. They're talking about, this is a really cool little song. So I'm going to play an exit song as we leave. I think it's pretty cool. It came from England. Thank you, Randy, for sharing it.
Like my father and mother before me. They taught me to fight for my civil rights, but it's always the same old story. The rich reign supreme while the poor can but dream of the Labour or Liberal or Tory. And I say
term is bent and the money's all spent. We're minded from every direction.
The workers get taxed while the well